Calendar for the day. The first bill on the calendar for the day is House File 2539. The clerk will report the bill.
House File number 2539, number 1 on the calendar for the day, an act relating to public safety, the first engrossment.
There are amendments at the desk. If there is no objection, we will let the author explain the bill before we act on amendments. I recognize the author, Representative Long. Will you please proceed with describing the bill?
Thank you, Mr. Speaker. Last month, we had an important step towards justice for George Floyd, but we know that the tragic shooting of Daunte Wright must call us to action as well. Daunte Wright's tragic death highlighted several shortcomings of our criminal justice system, and I want to thank Representatives Frazier, Moeller, and Becker-Finn for their work on stops for equipment violations. Representative Vang and I are partnering on the provision before us today to address what happened after the decision to stop Mr. Wright. Once the officers determined to pull Mr. Wright over for his expired tabs and air freshener, they found he had an outstanding warrant for failure to appear in a first appearance for a summons. But Mr. Wright likely never knew about this warrant because the summons had never been sent to an address from which mail had already been returned. These situations with incorrect addresses, unfortunately, are common. Some jurisdictions have taken a common sense approach where instead of issuing a bail warrant for failures to appear in their first appearance, where we know the individual never received the notice, they use a sign and release warrant. In these instances, an officer notifies the individual that they have an upcoming trial date and asks them to sign. This takes down the temperature in the interaction with police, as there is no need to take them into custody. It's important to note that the prosecutor has already determined in these instances that bail was not needed, which led to the summons in the first place. We've also added careful exclusions in the bill where there is a public safety concern, so this would not apply to any felonies or to domestic violence, assault, or DWI misdemeanors. Also, prosecutors can still seek an arrest warrant if they have concerns over public safety. The sign and release process has led to good rates of appearance for trial dates in the jurisdictions that have used it. This shows that individuals largely do want to come to their court dates when they know about them. It's my understanding that where these procedures are in place, they've worked well and they are well supported. They work for community because custodial arrests are reduced. They work for police officers who now are more available for emergency calls and for higher priorities. This would be at least one step we can take to try to reduce tension wherever possible when we know that it was prompted by a simple mistake in address. We received a $0 fiscal note for the bill, noting that the procedural changes can be absorbed within current budgets. And I would add this will also likely save money for local governments by reducing their need to pay for detention. I want to thank Representative Novotny for his counsel and advice on this bill, and Representative Stevenson for the bill idea. And Mr. Speaker, I would like to turn it over to my partner on this effort, Representative Vang.
I recognize the representative from Hennepin, Representative Vang.
Thank you, Mr. Speaker. Members, this bill honors the memory of Daunte Wright. We have seen in Daunte's last moments officers attempting to arrest Daunte because of a warrant he had issued for failing to appear in court in which he never knew about. This bill establishes a different option for the courts and law enforcement. Instead of arresting the individual, it allows courts to issue a signed and release warrant and directs the officer to provide defendants with that notice and have it signed that it was given. This is reasonable. Officers don't have to waste their time and resources on citizens who are not a public safety threat and will rather be useful for an emergency situation, while citizens can return to their daily lives after being informed that they missed their court date for a misdemeanor or a gross misdemeanor offense. I can't help but think, had this bill become law, perhaps he could still be alive today. Although this bill does not solve all the issues relating to why unarmed Black men continue to get disproportionately killed by law enforcement, it at least sheds some light to look at our justice system. The way that we set up our laws, policies, and structures impacts everyday citizens. Members, we also have to take responsibility for what happened to Daunte Wright. This is our opportunity to create a better working system. We all have a role to play in protecting the people of Minnesota. Our laws and policies meant to serve the people, meant to serve Dante, that day did not protect him. We must continue to improve our systems so lives are not unnecessarily lost like Dante and those before him. I ask for your support. Thank you.
There are amendments at the desk. The representative from Sherborne, Representative Novotny, offers the following amendment. The clerk will report the amendment.
Novotny moves to amend House Bill number 2539, the first engrossment. The amendment is coded A2.
To the author of the amendment, Representative Novotny.
Thank you, Mr. Speaker. The amendment is technically just cleaning up some language. I have spoke with the author, and I believe that he will take the amendment.
To the representative from Hennepin, Representative Long.
Thank you, Mr. Speaker. Thank you, Representative Novotny, for the amendment. This is a helpful clarification that what we're focusing on in this bill are individuals who did not have knowledge of their court date and who had a return summons because the address was incorrect. So I'd urge members to support the amendment.
Seeing no further discussion, all those in favor say aye.
Aye. Aye. Aye.
All those opposed say no. The motion prevails and the amendment is adopted. There is an amendment at the desk. The clerk will report the amendment.
Novotny moves to amend House Bill number 2539, the first engrossment, as amended. The amendment is coded A3.
I recognize the representative from Sherborne. Representative Novotny, will you please explain the amendment?
Thank you, Mr. Speaker. The A3 amendment is simply adding for someone that is issued the sign and release when they have contact with a law enforcement officer, that if they then subsequently fail to appear for that court date that they now have been duly notified of, that they would be subject to an additional misdemeanor.
The representative from Hennepin, Representative Long.
Thank you, Mr. Speaker. I would urge members to oppose the amendment. I believe that when summons is bouncing back because the individual hasn't received it, then we should give them the opportunity to appear in their first appearance, as we do for other defendants, without the possibility of having that turn into a misdemeanor. So I'd urge a no vote.
Further discussion. To the author of the amendment, Representative Novotny.
Thank you, Mr. Speaker. Under the current plan, there is no incentive for an individual to appear in court when it is scheduled. Under the current catch and release program, there's no incentive. Minnesota is a concurrent state. So if you plan on not changing your criminal ways and continuing to rack up violations, it is in your best interest not to appear until you finally get a warrant that results in you being dragged into court and in front of a judge. At that point, most of the cases will be dismissed. You'll plead guilty to one or two of the charges, and the rest will go away. This law is not needed. In Hennepin County and Ramsey County, they are already doing the book and release. They are doing this even on felony level cases. I was made aware that the Twins corporate office was recently broke into, and the staff came across the individual sleeping in the corporate offices. This individual had broke in, had filled several bags with merchandise before going to sleep. Now, when they ran this individual, he was found to have 2 felony warrants for second-degree burglary and other lesser warrants. And they were advised that this was another book and release warrant. So I don't think this is necessary right now. Obviously, Hennepin and Ramsey County are already doing their own extrajudicial process for this. So I do not believe, without some incentive, that this program, this current law, will make any difference. Without some penalty, some consequence. Thank you, Mr. Speaker.
Further discussion to the A3 amendment? Representative Novotny.
Mr. Speaker, I request a roll call.
A roll call has been requested. Seeing 15 hands, there will be a roll call. Discussion. The clerk will take the roll. Oh, we have discussion. Representative Pinto.
Thank you, Mr. Speaker. Members, as you may remember, I'm a prosecutor in Ramsey County, and I'm familiar with, as Representative Novotny said, this is in fact in use in many ways in Ramsey County and Hennepin County as well. But I speak against this amendment. The way that this is written is that, and let's recall, somebody is charged with a summons in this situation. That means that the prosecutors decided that in fact there are not the public safety concerns to issue a warrant in the first place. And somebody then misses the court appearance because of it having bounced back per the amendment from Representative Novotny that we've already adopted. And now this person fails to show up at the next court appearance and they're charged with a crime. There is no restriction in here to identify a situation where there may have been some particularly good reason. Perhaps the person is sick or in the hospital. Perhaps there's something that is going on. Perhaps, in fact, the probation officer has found that, in fact, for all frankly, Representative Novotny, the person could be in custody themselves. There's absolutely nothing written in here. And to turn in the fact of somebody failing to show up in court into a crime, to my mind, Representative Novotny and members, is not an appropriate way for us to go with this. The incentive that somebody has to show up in court is the incentive that there is all the way along, which is that, in fact, there can be a warrant issued if, in fact, they have notice of the court appearance. The way that this bill is written, with the amendment was adopted, the person did not have notice of the court appearance. Let's make sure to follow the method that we've used for decades and really for centuries. Say if somebody doesn't show up, want to secure their appearance, issue a warrant. But charging somebody with a new crime for that, to my mind, would be really not precedent and not something we should be doing. I'd urge a red vote. Thank you, Mr. Speaker.
Representative Novotny.
Thank you, Mr. Speaker. Representative Pinto, I understand your point. And there are weather incidents, there are traffic incidents, there are jobs, there are kids that get sick every day for people that have court. And if they do not show up, they make a phone call, and if the warrant is issued, they get the warrant quashed. This is a situation that is easily avoidable if there is an incentive for them to take care of it. The way this law is written, there is no incentive if we do not take my amendment. Thank you, Mr. Speaker.
The representative from Isanti, Representative Johnson.
Mr. Speaker, members, Representative Pinto brought up a little bit of a good point, but he forgot one thing: prosecutor discretion. The prosecutor can decline to add the new charges if he so desires, if there's reason that the person had a legitimate reason why he missed that court date. But I think it's important to incentivize people to show up in court when they have a summons, when they've been notified, and when they know they have a court date. This is a little bit of incentive never hurts. Thank you.
Any further discussion? Seeing none, the clerk will take the roll. Members, please vote. Will the clerk please call the names of those members who have not voted yet?
Davids.
Davids votes aye.
David's aye. Daphne. Davney.
Dabney votes no.
Davney, no. Drazkowski.
Drazkowski, aye.
And Drazkowski, aye. Franzen.
Franson votes yes.
Franzen, aye. Garofalo.
Garofalo, aye.
Garofalo, aye. Gomez.
Gomez, no.
Gomez, no. Gruenhagen.
Gruenhagen, aye.
Gruenhagen, aye. Haley.
Haley, aye.
Haley, aye. Hamilton.
Hamilton, aye.
Hamilton, aye. Hanson, R.
Hanson, R, no.
Hanson, R, no. Hausman.
Houseman, no.
Hausman, no. Heinrich.
Heinrich, aye.
Heinrich, aye. Hollins.
Hollins, no.
Hollins, no. Igo.
Igo, aye.
Igo, aye. Keel.
Keel, aye.
Keel, aye. Lucero.
Lucero, yes.
Lucero, aye. McDonald.
Donald, aye.
McDonald, aye. Mecklin.
Mecklen, aye.
Mecklin, aye. Mortensen.
Aye.
Mortensen, aye. Munson.
Munson, aye.
Munson, aye. Tice.
Tice, aye.
Tice, aye. Thompson. Thompson. Zhang Jie.
Jones, no.
Zhang Jie.
Thompson, no.
Thompson, no.
The clerk will close the roll. There being 64 ayes and 70 nays, the motion does not prevail and the amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
Bennett moves to amend House Law Number 2539, the first engrossment as amended. The amendment is coded A4.
I recognize the author of the amendment, Representative Bennett.
Thank you, Mr. Speaker and members. The underlying bill here has a list of exceptions or the crimes that are ineligible for these no-sign warrants. And my amendment would actually add a few more exceptions to this bill. And these would have to be gross misdemeanor gun-related crimes. For example, transferring a weapon illegally, purchasing a weapon for an eligible person, possessing a weapon illegally, those types of crimes. Members, when I looked at the list of exceptions on this bill, I was really shocked that these crimes were not listed. We all know that gun violence is a big issue, and we should have a no-nonsense approach to our current gun laws that we have on the books. And I don't understand why they're not in this bill. So I'd like to see them added in here. And when you think about it, even our schools take a no-nonsense approach to weapons. If you have a pocket knife in your pocket, they basically have zero tolerance for that. We should be having zero tolerance for our gun crimes. And, I find it ironic, too, that some of my friends on the other side of the aisle seem to want to add new gun laws on the books, gun laws that would quite often just make it tougher for law-abiding citizens to own a gun or purchase a gun, but seem a little more unwilling to go after the criminals who are breaking our current gun laws. And I'm hoping this just got missed here. And Mr. Speaker and members, I would ask that we would take this amendment and add these gun crimes to the underlying bill.
To the Representative Hennepin, Representative Long.
Thank you, Mr. Speaker. I ask members to oppose the amendment. We worked hard to exclude the crimes that pose clear public safety risks like assault or domestic violence. And in fact, we based our exclusion list in the bill on those that are in use in jurisdictions that use sign and release by the prosecutors there. So the prosecutors have determined already that the lists that we have are the appropriate exclusions. Also, I'll note that one of the crimes in the underlying amendment is carrying a firearm without a permit. And there is an active bill introduced by colleagues on the other side of the aisle to make this not a crime at all, to repeal that as a crime. So I don't think that this list rises to the same level of concern as the crimes like assault or domestic violence or DWI that we have listed. And we have also additional safeguards that are available. One is that in the bill, if there's a concern for public safety with any crime, then the prosecutor can seek an arrest warrant. And also these instances, as Representative Pinto mentioned, are already cases where the prosecutor has determined that a summons is appropriate rather than arrest warrant from the outset. So there already has been a determination that these individuals are not ones for whom there's a public safety risk and for whom a summons is appropriate. So for those reasons, I ask members to oppose the amendment.
The representative from Wright, Representative Lucero.
Thank you, Mr. Speaker. And I would ask for a roll call on this.
A roll call has been requested. Seeing 15 hands, there will be a roll call. Representative Lucero.
Thank you, Mr. Speaker. And would Representative Long yield for a question?
He will yield. Representative Lucero.
Thank you, Mr. Speaker. I just wanted to make sure that I heard Representative Long correctly. So Representative Long, can you confirm or deny I heard you correctly that you did not believe that gun crimes and hence the crimes that you've excluded are considered a public safety risk? Again, crimes with guns or gun crimes are not a public safety risk.
Representative Long.
Thank you, Mr. Speaker. Representative Lucero, I referred to the bill that you introduced, actually, which would repeal the crime altogether for one of the listed crimes in this amendment. So I think if you believe that that shouldn't be a crime at all, then you would probably agree that that does not pose the same level of risk as some of the other crimes that are called out in the bill.
Representative Lucero.
Thank you, Mr. Speaker. And while I do believe that law-abiding citizens do not pose a risk to society, and that is the reason I've introduced my bill, so that law-abiding citizens can carry and exercise their constitutional Second Amendment gun rights of shall issue. That wasn't my question. My question was, you have excluded crimes involving guns, not law-abiding citizens involving guns, but crimes involving guns. And the amendment before us seeks to remove that exclusion because if I understood you correctly, you said that you did not believe crimes involving guns pose a public safety risk. And so if the member would yield for another question, Mr. Speaker.
He will yield. Representative Lucero.
Thank you, Mr. Speaker. And Representative Long, because you didn't actually answer my question, if I heard you correctly, could you or would you be willing to confirm or deny my understanding that you don't believe that guns pose or gun crimes pose a public safety risk and is indeed the justification for your excluding them?
Representative Long.
Thank you, Mr. Speaker. As I mentioned in my remarks, the crimes that are excluded here are crimes like assault and crimes like domestic violence. Those are the exclusion lists that are actively used by prosecutors in the jurisdictions that have the sign and release approach. And the list of crimes here are not equivalent, in my view, to those. As I mentioned, they include crimes like the ones that you do not believe should be a crime at all. And as I further mentioned, there is a safeguard for if any prosecutor believes that there is a public safety risk, that they can seek an arrest warrant with a judge under this bill.
Representative Lucero.
Thank you, Mr. Speaker. And that's all I have. Just to reiterate here one more point, and that is, I absolutely do believe that it is not a risk to public safety that law-abiding citizens carry firearms. Thank you, Mr. Speaker. Please vote green on this fantastic amendment.
The representative from Anoka, Representative Scott.
Thank you, Mr. Speaker and members. I just want to, first of all, I'm just amazed that the other side of the aisle who pushes repeatedly for more gun control is willing to give people that are committing gun crimes a pass with this bill. here's an instance, so just some of the things that you're excluding from this, and you're just going to look the other way and let these people, if they're found having committed one of these crimes, that you're going to just look the other way and say, here's your little summons, show up in court. Crime committed for the benefit of a gang. Escape from custody for a misdemeanor or gross misdemeanor crime. So they've escaped custody and you're not going to haul them in. Persons ineligible to possess a firearm. We know that many gun crimes and violence is committed by people that are in illegal possession of a firearm. Knowingly making a false statement to obtain a firearm transferee permit, purchase a firearm on behalf of an ineligible person, the straw purchase that you folks on the other side of the aisle just wail about all the time. You think it's this big loophole. Carrying a pistol without a permit, transfer of a firearm to an ineligible individual, and allowing an ineligible person access to a firearm. So you're willing to look the other way, just give these people a piece of paper and say, please show up in court this next time when your date is, the date that's on this summons, please show up. I just find it just so hypocritical that the same people, and I'm guessing Representative Mariani, that you're probably going to be voting for the bill. You're not going to vote for this amendment, but you seem to be very committed to getting guns out of the wrong hands. And with this amendment, we're trying to do the same thing, and you're going to oppose it. I just find that extremely hypocritical. Members, please vote green on this amendment. It's a good, sensible amendment. Thank you.
The representative from Chicago, Representative New Brindley.
Thank you, Mr. Speaker. Honestly, I'm a little dumbfounded right now. Representative Long said that the things that are excluded are things that have a clear public safety risk. And of course, the implication of that then is that the things in this amendment do not provide a clear public safety risk. Honestly, that is absurd. We're talking about someone who is prohibited from possessing a firearm, who has a firearm. How in the world is that not a clear public safety risk? We're talking about straw purchases. If you don't know what that is, it means somebody purchasing a gun on behalf of someone else who cannot legally obtain one themselves. That is a clear public safety risk. We're talking about lying in order to acquire a firearm, illegally carrying a firearm. How in the world do these things not show a clear public safety risk? This is the most bizarre political decision I have ever seen in this chamber. And we've seen some bizarre things, frankly. I am honestly dumbfounded. From the party that is so anti-gun for law-abiding citizens who do none of these things, and now we're going to say that somebody who is carrying a firearm illegally, and that is very purposeful, does not pose a clear public safety risk? And honestly, this idea that, this is what other jurisdictions do, well, with all due respect, we are writing laws for the state of Minnesota. I don't really care what other jurisdictions do. I care about doing what's right for the people of Minnesota. And certainly, people involved in gun crimes, people who are carrying firearms illegally, people who are purchasing firearms illegally, pose a clear public safety risk. This is bizarre. Members, support this amendment.
The representative from Wright. Representative O'Neill.
Thank you, Madam Speaker and members. I'm wondering if Representative Long would yield to a question.
He will yield. Representative O'Neill.
Thank you, Mr. Speaker. Representative Long, when you came to public safety and we looked at your bill, it was kind of late. It was about you had just introduced it 10 days before, and law enforcement didn't have a whole lot of time to weigh in. We didn't have a lot of time, thanks to Representative Winkler, who took up most of our time in committee with his marijuana bill. God bless you, Representative Winkler. We appreciate that. So, you know, I read through the bill. I read through the bill language. I read through the bill summary. And I came upon a phrase that Representative New Brantley just discussed, and that had to do with if the prosecutor deemed that that person was unsafe, so they were a danger to the public. And I looked at that and thought, okay, so there's our catch-all. So you had a long list of exclusions, which I appreciate, and you even said to me later privately that, you know, you kind of took a list that I've used in the past, or a liked list. But when I dug in a little bit deeper, I realized that, oh my goodness, 624 is not in it. So the ineligible person to possess a firearm. And so I started thinking about that, like, well, okay, so who's on the list? Who are the ineligible people? And then I hearkened back to what just happened in my own community in Buffalo. And we had somebody who is deemed ineligible because of mental defect to stand trial. So they were through a Rule 20, they couldn't stand trial. So I had these really great concerns after the fact. And I started looking at that and I thought, wow, that's really an oversight. So when Representative Bennett brought this amendment, I thought, well, this is great. That'll close that loophole, because I certainly thought that you meant to close that loophole of somebody that was ineligible. So somebody that was so mentally ill or dangerous that they couldn't possess a firearm. And that's actually a lifetime ban. And I'm a little bit surprised that, in fact, you meant to write it that way. I'm disappointed. So my question to you is, let's go back to the catch-all that you talked about and we talked about privately offline. And this catch-all is where the prosecutor basically has to determine that that person is a danger to the public. And I'm wondering if you could explain to the body, Representative Long, what process that prosecutor has to go through to make that determination. Because we're talking about a really, really dangerous person that obviously had been in possession of a firearm that should not have been, and a warrant was issued. And whether they got it in the mail or didn't, it's kind of irrelevant to me, because you're talking about someone that is very dangerous, that is in possession. It happened in my own community. Now, in my community, there was a clerical error, but that person should not have been able to possess a firearm because they failed a Rule 20. So, Representative Long, could you just tell the body, what does the prosecutor have to go through to keep the public safe?
Representative Long.
Thank you, Mr. Speaker. Thank you, Representative O'Neill. So I think it's important to remember two things at the outset. The first is that in all of these circumstances, the prosecutor has already determined that the individual is not a danger. That is why they're giving them a summons rather than requiring a warrant for their arrest. So the summons by itself has required the prosecutor at the outset to make a determination that that person is not a danger to remain in society for every single case that we're talking about here. And then the second thing to remember is that for every single case we're talking about here with the amendment that we've adopted from Representative Novotny, these are individuals who have not received notice of their court date, right? So that's why they're not appearing. So the exemptions that we have, I think, are being overly conservative to say, even though the prosecutor has determined that these individuals are okay to remain in public, and even though that individual did not receive notice of their court date, we're still saying that there's a certain category of crimes for which that doesn't matter. We're going to presume that that person's a risk to public safety, even though the prosecutor had determined at one point that they were not a risk. Just by failing to miss a mail that they never got, we're saying those people are a risk. So that's how conservative the approach is right now. And then if you're looking at the exemption, we're adding in an additional safeguard, which is saying that the prosecutor can make a demonstration to the court, very broad. A defendant poses a risk to public safety for a safety of a victim or because a defendant otherwise poses a danger to themselves or others. So they would just need to go to the court and say, here are the reasons why we believe this person poses a danger to themselves, poses a danger to a victim, or poses a danger to the public. and the court would then would grant a bench warrant for an arrest. So I think that we have a lot of safeguards in here for the public in that these circumstances are one already where the prosecutor has determined that there is not a risk to them remaining in public, even for these crimes. We have to remember these are individuals who are accused of crimes but have not been convicted of anything, and they deserve their fair day in court, and individuals who have not received the notice to even appear for court.
Representative O'Neill.
Thank you, Mr. Speaker. Thank you, Representative Long. I appreciate that. I appreciate you letting the body know. And what I'm confused about, though, Representative Long, is that the long list. So if you violated DANCO, if you violated an HRO, if you violated OFP, so these are all a danger to particularly women and children mostly, but not exclusively. If you have committed domestic assault or simple assault and so on and so on. So the list is very clear that these are crimes of violence. In fact, at first, when I first glanced at the list, I literally thought it was the list of the crimes of violence, but of course it's not. It's a different list. But just what you just said, I don't see why you wouldn't accept this amendment to then further exclude ineligible people to possess a firearm that have been in possession of a firearm. So you're talking about people that we have decided, like I gave you an example of someone that is mentally ill or dangerous and should not be possessing a firearm, someone that has had chemical dependency treatment, and there's a period of 3 years before they can apply to possess a firearm while they're still kind of getting their life in order. There's a whole long list that there's a reasons why someone is an eligible person. I don't really understand why you wouldn't accept this amendment. It really is in line with everything else that's in your list. I really thought it was just an oversight, and I thought that you would just accept this amendment. So I'm disappointed that you are not in support of accepting this amendment because it just seems pretty common sense. And, you know, Representative Long, I've done this for a while, and I really did just think that you just missed it because it came very quickly. You introduced it, we heard it in 10 days after that. It's really late in session, it was past deadline, and so things get missed, right? So things can be confusing and a little unclear. So I was really hoping that you would just close this loophole because it really is. It's something that is a loophole, and I think that we absolutely need to tighten it up. So I just would ask you to reconsider and ask the body to reconsider that this really is a very dangerous part to not have in. And I appreciate what you said, that the prosecutor can go, to the court and present the case and all of that, but or we could just put this in and he wouldn't have to do that. So the body, I hope that you support this amendment and maybe just reconsider what you just said, Representative Long. So I think this really is an oversight. Thank you, Mr. Speaker.
The representative from Ramsey, Representative Moeller.
Thank you, Mr. Speaker. And I just wanted to mention that some of the items in this list, I was confused when I first saw the amendment because there are actually many felonies within this, and it's my understanding that those are automatically excluded from this. So any of the felony charges would be excluded. Thank you.
The representative from Anoka, Representative Rowley.
Thank you, Mr. Speaker. Members, what I want to do is draw your attention to how this bill is crafted, and I need to look at the bill itself before I get into the amendment that we're discussing right now. What happens in this bill is on subsection 3, it says the court shall issue a sign and release warrant if. And that's really what we're debating here with this particular amendment. Now, the amendment specifically says that they shall issue unless there's other than a violation of, and then we talk about 299C.10. So I'd like to take a look at the point 10, and it calls out 169A.20, which is DWI, 518B.01, which is domestic abuse orders. And so if we take a look at 518B, specifically the domestic abuse orders, it calls out in its language 624.713. And then it goes on with the violations for resisting orders, violations for domestic abuse, domestic violence, which is 609.2242. And specifically, not in the bill itself, but added, not in 299C.10, there were several that were added. Specifically, 609.2231, fourth degree assault, then criminal sexual conduct, malicious punishment of a child, child neglect, harassment. These are all crimes that we can clearly understand, and we get a good sense of what the author is trying to do with this bill. Specifically in 518B.01, it calls out 624.713, which then says specifically in here that a person who is subject to an order for protection is described in 206C.201, subdivision 3, paragraph D, 518B.0.01. That references the House File 2539 that we're discussing here. All of this to go into the question of when does this talk about firearms? And it specifically does when we're talking about assault in the 5th degree, which is in the bill itself, and this amendment would help to clarify. What I'm stating as why it would clarify is because, and I will read 609.224, assault in the 5th degree, subdivision 3, firearms. When a person is convicted of a violation of this section or section 609.221, and there's several others, the court shall determine and make written findings on the record. And then it goes on from there specifically talking about it. Now, not in the bill, but in 299C.10, I want to point out three things that are not in the bill, but are in 299C.10. 5th degree assault, petty or privacy violations, and indecent exposure. Now, I understand why the author left these out, because we understand that these are specifically things that we want to avoid, and we don't want to, we want to list those as crimes that will have a warrant issued for those. So because they're so obvious, they're not called out in the bill itself. And that's why I think that this amendment is so important, because it's clarifying what we're going to codify into law to make sure that when we take the words shall issue and then give that to our judiciary, which I think when we get into the bill itself, not the amendment, I really think we need to talk about the shall issue as opposed to the may issue. The Amendment 4 adds 624.713, which is not possessing firearms, which also references 518B.01, and making false statements, which allows an ineligible person to access the firearms. So the rest of the points that I've got all specifically go to the bill and not the amendment, but the amendment itself, I think, does enhance this bill. It clarifies and codifies what the intent, I believe, of the author is. And we understand that in the bill, there are certain sections of 299C.10 that were not called out in the bill, but are in that particular part of the statute. We understand that they were not called out in the bill, and our amendment, this amendment, helps to clarify and codify this particular area. Thank you, Mr. Speaker.
The representative from Stearns, Representative Tice.
Thank you, Mr. Speaker. I just want to, this is one of those moments where I'm really not sure what I should be doing, because right now in my district, at one of the banks, there is a hostage situation. So do I think that Representative Bennett's amendment is worth keeping? You bet I do. My phone has been blown up with text messages, and as soon as I can, I'm getting on here and seeing what's going on and how I can help. But do we need to take this seriously? Yes, we do. Yes, we do. I have no clue what's going on, but I know this has been going on since 1:48 this afternoon. The SWAT team is out there, and it does not sound like it's resolved. Is this something we need to look at? You bet it is. This amendment is very important to making sure that communities are safe. And right now, I'm just praying that everybody I know is safe, and I'm praying for all the folks that are there. I'm praying for all the folks that are there, trying to get through this day and be alive. So this amendment is very important in many different ways. I understand what you're trying to do, but when it comes to things like this, I don't think there are a lot of second chances. So please vote yes for Representative Bennett's amendment. Thank you.
The representative from Isanti, Representative Johnson.
Mr. Speaker, members, it just pointed out that some of the things in this amendment are felonies, and that is true. But everyone listed in Representative Bennett's amendment as a gross misdemeanor content as well. I also looked up a number of states that had these things. I could not find one. There's a few cities around that do, but in those states, both Washington State and Kansas State, it's a felony to illegally possess a firearm. So that's why they're not listed in their bill. Thank you.
To the author of the amendment, Representative Bennett.
Thank you, Mr. Speaker, and thank you to Representative Johnson for clarifying that. I did double check before I had this amendment drawn up that these are not felonies that are listed here. They are actually gross misdemeanors, and so they would not automatically be included as ineligible for these sign and release warrants. And Representative Long, it's mind-boggling to me right now. I never thought in a million years that you would not accept this amendment. It seems common sense to me. It seems, with the prevalence of gun crimes nowadays and the effort to try to curtail that this would just make sense. I am mind-boggled right now over this. And I think not only is this a public safety issue, but it's a perception issue. We need to have the perception that people who break our gun laws, that we mean business with that. In my first grade classroom, there were certain infractions that my students that I just took a no-nonsense approach to. And it was not a little minor slap on the hand thing. That was a big deal. And when people break our gun laws, it's a big deal. We should show them that we mean business. We should show them that we're not going to coddle people who break our gun laws, who are criminals, who transfer weapons illegally, who carry weapons illegally. That's a perception we don't want to give. So I would ask for a green vote on this common sense amendment. I really can't figure out why people would not vote for this and add these gross misdemeanor crimes to the ineligible list. And let's take a stance and say that criminals who break our gun laws, we mean business. Thank you, Mr. Speaker.
Seeing no further discussion, I do see further discussion. Representative New Brindley.
Thank you, Mr. Speaker. I just want to make a real quick point to clarify what Representative Long said. He was making the point that a prosecutor decides to issue a warrant or a summons, and under this, the prosecutor has chosen to issue a summons instead of a warrant, and they've made the determination that they're not a danger to the public. So why do we have exclusions at all? Why do we have exclusions at all in this bill? Because what you are saying is that the exclusions that you have in this bill right now, and if we do not accept this amendment, that means that a police officer cannot arrest someone for trafficking firearms, but they must arrest someone for slapping someone in a bar. That's 5th-degree assault. Slapping someone in a bar, they must arrest them. Trafficking firearms, they cannot arrest them. If you vote no on this amendment, that is what you are saying is reasonable public policy. If you vote no on this amendment, you are saying that a person who slapped someone in a bar is more dangerous, presents more of a clear public safety risk than someone who is trafficking firearms. That is what you are saying if you vote no on this amendment. There is not a person in the state of Minnesota who will say that that is a reasonable decision. Do the right thing, vote yes on this amendment.
Further discussion to the A4 amendment? Seeing none, the clerk will take the roll on the amendment. Members, please vote. Will the clerk please call the names of those members who have not voted yet?
Anderson.
Anderson, yes.
Anderson, aye. Baker.
Baker, aye.
Baker, aye. Christensen.
Christensen, no.
Christensen, no. Davids.
Davids votes aye.
Davids, aye. Davney.
Dabney, no.
Davney, no. Drazkowski.
Truskowski, aye.
Drazkowski, aye. Franzen.
Franzen votes yes.
Franzen, aye. Garofalo.
Garofalo, aye.
Garofalo, aye. Gomez.
Gomez, no.
Gomez, no. Gruenhagen.
Gruenhagen, aye.
Gruenhagen, aye. Haley.
Haley, aye.
Haley, aye. Hamilton.
Hamilton, aye.
Hamilton, aye. Hanson, R.
Hanson, R, no.
Hanson, R. No. Hausman.
Hausman, no.
Hausman, no. Heinrich.
Heinrich, aye.
Heinrich, aye. Hollins.
Hollins, no.
Hollins, no. Igo.
Igo, aye.
Igo, aye. Keel.
Keel, aye.
Keel, aye. Kosnick.
Kosnick, aye.
Kosnick, aye. Lucero.
Lucero, Green.
Lucero, aye. McDonald.
McDonald, aye.
McDonald, aye. Mecklin. Mecklin, aye. Mortensen.
Mortensen, aye.
Mortensen, aye. Munson.
Munson, aye.
Munson, aye. Schultz.
Schultz, no.
Schultz, no. Sundin.
Sundin, no.
Sundin, no. Thompson.
Thompson, no.
Thompson, no. Zhang Jie.
Zhang, no.
Zhang Jie, no.
The clerk will close the roll. There being 65 ayes and 69 noes, the motion does not prevail and the amendment is not adopted. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, House Bill number 2539, as amended.
Third reading. One second. Representative Stevenson.
Well, thank you, Mr. Speaker and members. I would encourage people to vote in favor of this bill. It's a common sense bill. I wanted to talk a little bit about it from my perspective, like Representative Pinto and Representative Moeller and Representative Becker-Finn. I work as a prosecutor. I work as a prosecutor in Hennepin County when the legislature is not in session, and for years before I was elected to the legislature. And so I have some direct experience I can bring to bear on this question. And I wanted to talk a little bit at the outset about charging someone with a crime. Because it's kind of a very unique experience that I don't know if I can emphasize to the body how serious it is and how serious as a prosecutor you take it when you charge someone with a crime, particularly a serious crime, particularly a felony. Because when you charge someone with a crime, you're doing a number of different things. One, you're saying that you have the evidence to prove that the person committed the crime, but you also have to know that when you're charging someone with a crime, you're changing that person's life for the foreseeable future, particularly, again, if it's a felony, right? Because being charged with a felony has really serious collateral consequences. Someone does a background check and sees that you were charged with a felony or charged with a serious crime, they might be not very likely to hire you for a job or not very likely to give you a place to live and a rent. It can affect relationships. It has very serious consequences. So as a prosecutor, you feel a great deal of weight at that moment, and I'm seeing Representative Pinto nodding. I'm sure he feels the same way. In fact, I know Representative Pinto makes a lot of charging decisions. And it's a heavy moment that you take very seriously. You take very seriously each step of that process as you think about, do I have the evidence to satisfy each and every element of this offense? Which offenses should I charge? What is in the interest of justice? And how should I charge that offense? Should I charge it as a summons, as a warrant? These are serious decisions because if you charge something as a warrant, the person's going to go into custody, and going into custody, as the licensed peace officers in the room know, is something that isn't always without complication. And you shouldn't ask for someone to go into custody unless it's necessary and the right thing to do. And so it's not a decision that prosecutors take lightly to issue a summons or issue a warrant. So if someone is charged by summons, as has been said by many people in the room, it is because the prosecutor made a reasoned and thoughtful decision that this person does not need to be in custody pre-trial. And that is one independent reason to vote for this bill, because the only thing that's changed is that they missed a court date that they had no notice of and couldn't possibly have made it to because they had no idea it was happening. But think about this practically for a minute, because the other experience that I've had as a prosecutor is handling first appearances. So I've been in a courtroom, Representative Novotny mentioned that Hennepin County does this already on book and release warrants, and sign and release warrants on felonies, and that's true, but we haven't done it for very long. It hasn't been the entire time that I've been a prosecutor. I was a prosecutor at Hennepin County before we had this policy. And I was in the courtroom doing first appearances where we had people who were charged by summons, the summons was returned mail, they were arrested on that bench warrant, and they come before the judge in custody. And I have made the argument to the judge at that point that the person should stay in custody. You know what the judge says in that situation? They look at you and they say, really? What changed, Mr. Prosecutor, Mr. Stevenson, for the state? What fact has changed for you now that you think that this person is a public safety risk today and you didn't when you charged it, and the only thing that's different in between is they missed a court date that they didn't know about? And I'm here to tell you, no judge is going to hold someone in custody in that situation because the state has already said that the person is not a threat to public safety and does not need to be in custody. They've already said it. But it's not without consequence for the individual. Now, obviously, Mr. Wright's case brings that close to home, but that isn't all you should think about. Because when someone goes into custody, it's a disruptive experience for their life too. And we hear all the time, if you're a prosecutor in court, about people who lose jobs, who have children that they are responsible for. If you've got a bench warrant for your arrest that you don't know about because you missed a court date that you didn't know about, you're not going to be expecting to be arrested. And so you might have a little child at home who's waiting for you to come back And you might not have anyone to go take care of that person. Or it might be a pet, or it might be that you have a job that you're supposed to be to in a couple hours and you have no way of letting the people know. Or let's say that the charge comes out of Hennepin County, but you live way out in greater Minnesota. You live up in Duluth or Roseau, and you get arrested up there. Well, then you're going to be transported down to Hennepin County to see court. And so it's not just like one night at the jail, the next day the judge lets you out. It's like you're going to be in this for a little bit until you get down to Hennepin County and you see a judge. And that is really, really disruptive for people's lives. All because they missed a court date that they didn't even know about. And all so that a judge can say, here's your next court date. You're being released, no bail required. That's not a good use of state resources. It doesn't make any sense, and it leads to all sorts of crazy outcomes. In Hennepin County, we have started to do this, sign and release warrants, and the results are really good. People who get the sign and release warrant, turns out they come to court. Because while, let me tell you, I have run into people who have a rich bench warrant history where they miss court time and time and time again, even on the same file or on multiple files. Those people exist. There are people who don't show up to court and it's a problem. But most people make their court dates. Most people know that they need to go to court and that it's serious. And if they don't go to court, it's going to get worse. There is an incentive to show up for court. That incentive, there's lots of incentives to show up to court, not the least of which you're going to get a bench warrant. You're going to go to jail if you don't, eventually. But most people go. Most people go even when they're facing serious jeopardy of incarceration. I've had people show up for court when they are facing lengthy prison sentences. So I think this is a common sense bill. I think it's been a little unfortunate that the debate has gone the way it's gone so far today. And I urge members to support it.
The representative from Candy, Ojai, Representative Miller.
Thank you, Mr. Speaker. And Representative Long, I first want to thank you for calling me a handful of days ago. We lose track of time, and you explained this bill to me. And I want to thank Representative Novotny for answering some of my questions, Representative O'Neill, and we've had a lot of discussions among some of us members on this. And full disclosure, I've been back and forth on this bill because of those conversations. Listening to the debate here has put me somewhat back and forth. And the reason why I bring that up is oftentimes when we don't want to vote for a bill or we want to vote no, we sometimes bring up the process, sometimes bring up procedure and things like that, and it kind of diminishes the truth behind some of those things. But I think in this case, members, it does apply. I looked it up. It does not have a Senate companion, which means not only have they not talked about it, it isn't even over there. And I'm also concerned, I have been concerned, some of these reform bills that have come out of the tragic shooting and killing of Dante Wright have been right on the heels. And even some people, you know, with my side of the aisle, as they say, have put together some bills and stuff. And I said, you know, it sometimes isn't good to do policy right on the heels of a tragic situation. Hearing the discussion here today, I think there's some more time needed on this. I think it can be put in a way that everyone can support this and vote for it, and it's something that we can actually get into law. I just don't think that this is the time that we should be doing that. So again, I do want to say, Representative Long, I believe your sincerity in this, and Representative Vang, I believe the sincerity in this, and the discussion that we had really points to that and points that we're trying to do something right. I think we can. I don't think this is the time to do it, and so I will be voting no today. Thank you.
The representative from Wright, Representative O'Neill.
Thank you, Mr. Speaker. Members, I'm wondering if Representative Long would yield to a question.
He will yield. Representative O'Neill.
Thank you, Mr. Speaker. Representative Long, there's something in the bill that really has been bothering me, and I didn't ask it in committee, so I'm going to ask it here because it just is gnawing at me. And maybe it's a simple answer, I don't know, but it's specifically on line 2.24 if you have the bill in front of you. Starts in line 2.24 and it says, so this is when the officer has pulled somebody over and they're giving them the new court date, and it says the defendant may be asked to sign a form acknowledging the receipt of the notice. The defendant may not be required to sign the acknowledgement. Representative Long, why do they not have to sign the acknowledgement? I mean, when we sign something, it's sort of like sealing the deal. It's promising, yes, I'm going to go to court. So why are we saying that they don't even have to sign the notice?
Representative Long.
Thank you, Mr. Speaker. Thank you, Representative O'Neill. It's a good question. So this is to deal with a circumstance where you have an individual who is refusing to sign for some reason, and the goal is to try to avoid putting the police officer in a situation where they would have to force an individual to sign in some way. So they would still, as it's noted here, the police officer may indicate that notice was given and that the defendant refused to sign. So that would be taken by the court as an acknowledgement that the person received notice of the court date, but would not actually require a physical signature.
Representative O'Neill.
Thank you, Mr. Speaker. Representative Long. I mean, I can kind of see that, but, you know, I feel like with every bill, it just keeps going in a certain direction, and I guess it's supposed to make it easier for everybody, but, you know, when you sign on the dotted line, it's basically saying, you know, I'm promising to fulfill my end of this deal because I did something wrong, I missed my court date, I'll be there. Now, I didn't get the notice. We did clarify that with Representative Novotny's amendment. I appreciate that. But I'm not sure exactly what we're doing with this bill, Representative Long. And I liked it when it came through committee, and then I have been digging in and thinking about it more, and I'm just not sure. I'm kind of where Representative Miller is. This came late in the session. You know, it came in on the 17th. We heard it after deadline. We didn't have a whole lot of time to discuss it in committee. We're way after deadline at this point. So I don't know. I would have loved to have a little bit more time and have law enforcement weigh in. We didn't really hear a whole lot from them because we just didn't have time. They haven't had time to vet this and look at it. And this particular part gives me a little bit of pause. And I think what gives me greater pause is the fact that you wouldn't accept the misdemeanor, gross misdemeanor part of what Representative Bennett was putting in. They weren't felonies. They were gross misdemeanors of a prohibited person in possession of a firearm. There was a whole list of them. So I'm not really sure. I don't know what to think about this. I'm still legitimately undecided, as I know Representative Miller is also kind of swaying back and forth, but I'm just not quite sure what this is supposed to accomplish other than just let that person go again. I don't know. So I don't know, maybe in this last bit of debate in your closing arguments you can convince me, but right now I'm just not convinced. And I appreciate the bill, and maybe you should bring it back next session. We have plenty of time next session to work on this where we can fully vet it. We can hear from all the parties involved, especially law enforcement. So we need to really be mindful of what we're doing to our law enforcement, Representative Long and members. And I think, you know, I know we're trying to make things better, but I'm not sure that this does. I'm not sure that this makes it better for all the parties involved. And at what point do we get where somebody that's 18, 19, 20 years old just says, you know, I think I was going to go into law enforcement, and after I see what's been happening, I'm just not going to. And then the other thing I'm fearful of, people my age, so I'm 51, and I think you're going to see all kinds of men and women in law enforcement saying, I'm kind of done. I'm just done. I'm going to take early retirement. So I appreciate you were trying to make it easier for law enforcement, but you know what? We didn't have an opportunity to hear from them. And the few law enforcement people that I reached out personally didn't like it. So, and I don't know if they looked at the amendments or not, and if that makes them more comfortable, I'm not sure, but I think that if we had accepted Representative Bennett's amendment, I think I could easily be a yes at that point, but we didn't. And so I'm just not quite sure. And I'm going to listen to the rest of the debate, Representative Long, and hear what your closing arguments are. But I'm just not sure, members. This It's a little bit rushed, and I'm very unsettled, and I don't like that. I don't like to vote on bills when I'm unsettled. So thank you, Mr. Speaker and members.
The representative from Ramsey, Representative Pinto.
Thank you, Mr. Speaker. Representative O'Neill, I'm going to attempt to settle things for you and help try to provide a little bit of help. I know that you were listening, and I hope the colleagues that you were as well, to Representative Stevenson's remarks, because I thought that he walked through things so well and so clearly for us, and I have to say pointed out a bunch of things that I had not even thought of. Let's remember, members, that we're thinking about situations where somebody maybe has an arrest warrant from Hennepin because of a situation again, where maybe something was a bounce back. They're now in northern Minnesota. They have to be brought all the way down simply to then go back up again. Members, Representative O'Neill, let's remember that with the amendment that was added on by Representative Novotny, this only applies to situations where a summons was issued, it went to an address, and it bounced back. The person did not know, does not know about the hearing. So what this bill does is says that if you don't know about a court hearing, it's probably not fair for there to be an arrest warrant for you missing a hearing that you did not know about. That's the critical issue here. So keep in mind, these are only situations where somebody does not know about a court hearing. It's a situation where the prosecutor, as Representative Stevenson said, has made the decision at the start. This is a situation where we're not so concerned about an immediate public safety risk, and so we can have a summons be issued. Representative Johnson spoke very highly about a prosecutorial discretion earlier. On behalf of prosecutors, I appreciate that. We want to be careful about that discretion. This is a case where Representative Johnson, the prosecutors exercised the discretion to say a summons is appropriate. They've tried to use a summons, and it bounced back. And now we've got a court hearing, we've tied up a prosecutor, we've tied up the judge, you've got everybody there. The person can't show up because they don't know about the hearing. And our law requires at that point, the only option for everybody to use is to have an arrest warrant issued. And what happens then? Then an officer goes out, has this warrant, they encounter the citizen, and at that point the only option is to execute an arrest warrant to bring the person back to show up in court, whereas Representative Stevenson said, they're going to get released and be given another court hearing. Because of course they are, because there was a summons in the first place. And as Representative Stevenson said, no judge is at that point going to issue a warrant. There was a summons already issued. This, members, gives another option for our system. It says to our system, if you have a summons that nobody got the hearing, then at that point, we should make sure the person does get to know about the hearing. And we should not put them in jail at the expense to our counties, at the expense to our communities, at the risk to our officers, and at the burdensome and burdening our citizens. Members, I know my colleagues on the other side of the aisle care a lot about personal liberties and civil liberties and freedoms. Members, this seems like a pretty critical freedom that you don't know about a court hearing and now you've got a warrant for your arrest because of the hearing that you did not know about. And remember, it's not about the crime that you're charged with. And I actually do kind of see the point that was made. There may or may not have even been a need for some of these crimes that are listed in here as exceptions because the decision was already made for a summons to be issued. And if there's concern about public safety, there's a whole path that can be followed on that as well. There are so many protections built into this whole thing, but fundamentally, you shouldn't be issuing a warrant if the person doesn't even know about the hearing. Members, please, I urge you, let's give this as a possibility for our citizens and for our officers. It works well for everybody. Again, it is in use in some communities. We want to make sure that the whole state has the opportunity to take advantage of this. Members, I would urge you to vote green. Thank you, Mr. Speaker.
The representative from Isanti, Representative Johnson.
Mr. Speaker, members, I've looked at this bill and have concerns. First concern was that it did not go to judiciary. This is the judiciary bill, not a public safety bill. It belongs in the Judiciary Committee. It deals with the courts and how the courts operate in issuing warrants. As judges issue the warrants, prosecutors request them. It's judges that issue them. Well, Representative Stevenson did a nice job explaining some of the things. But what he left out is very rarely is there a body-only warrant issued for a misdemeanor or a gross misdemeanor offense. Most misdemeanor and gross misdemeanor warrants have a cash bail option. And if you get picked up in Roseau, chances are you probably have a relative up there who will come and bail you out. So you don't have to get transported down to Hennepin County. A lot of this stuff started because of the city of Minneapolis. I don't know if you're aware of it, but I'm sure Representative Stevens is because of he works with the Hennepin County Attorney. In their charter, 470.40 subdivision E states, if any person who received a notice or summons as provided in this chapter fails to appear within the specified time, the Traffic Violation Bureau shall forthwith have a complaint entered against him and secure and issue a warrant for his arrest. The Traffic Violation Bureau shall not accept fines from such person. So if you miss your court date and don't pay your fine by that court date, you don't have an option. I think the city of Minneapolis needs to fix their charter to start with to give people an option to take care of it before there is a warrant. Or let me sign a release so they can take care of it. Now, I know this is deals with an unfortunate incident that happened in this, and unfortunately, a life was taken. It's going to go through the system, through the courts. We'll see what happens. I feel sorry for the family and for the officer involved. It was a tragic event. But in law enforcement across this country, the latest numbers from the Department of Justice, or law enforcement had 3 million, actually over 375 million contacts with people across this country. And unfortunately, we had a little less than 1,000 people that lost their lives during those contacts. One is too many. I want to stop all of them. But unfortunately, I don't believe that will ever happen, as we have a big issue with suicide by cop. And it usually destroys that officer's life. We have some other issues. As I stated earlier, the other cities that, like I say, I haven't found a state that has this. I've found cities that do. New York, Pacifica, Washington, Kansas City, Kansas. And the firearms are not listed in their bills and what they do it because it's a felony there for that somebody to illegally possess a firearm. So they wouldn't have firearms on their bill. I've also talked to my sheriff about this. They're intrigued on this issue and they're looking at it. But they haven't had a really time to sit down and discuss it, sit down and digest what it is, how it'll affect their office, how it'll affect the safety of their citizens and their communities. Unfortunately, we haven't had a good dive into it. We had a short hearing after Representative Winkler's marijuana bill the other day. And we didn't have a real good lot of time to really dig into the bill and ask a lot of questions, find out how it works. I've dug into it a little more since then, and I do have some concerns. But I also understand it's gotten a little better because it just deals with summonses that were mailed out. And I have a story about a friend of mine named Phil. He lives in Hennepin County. He was doing work on his home, on his yard. And it happened to be very wet that year, so he didn't get a lot done. He had a lot of trouble because of the mud that he was dealing with, replacing his driveway. And he kept getting these letters from Hennepin County, or the city of Minneapolis. He's gotten so many, he kept just throwing them away, not even opening them. Turns out a couple of them were summonses. Finally, one day, he's out there working. Squad car pulls up. They haul him into jail because he hadn't appeared in court for his court notice for the zoning violations and not finishing his project on time. He went before the judge and he said, "Yep, I'm guilty. I didn't realize there were notices. I'll take my consequences." And he ended up spending a week in the workhouse. Had a good conversation about him afterwards. And So I can see how that is, how it works. Maybe on these summonses to make sure that they're delivered, maybe we should require the courts to start sending them certified return receipts so they know they get them instead of just returned. A lot of times they'll put them in the mailbox and they're returned and they don't even know that, because I get mail for people that have never lived in my house and I built my house. I don't send it back. A lot of times they just throw it away. So maybe we need to look at a different way to sending these summonses out instead of doing this to make sure we do that with this bill. And those are some of the things we need to look at and spend time diving into with a bill like this. Instead, we heard this bill was entered a week after deadline. A week and a half later, we had a short hearing on it, and now we're having it on the floor. And it didn't even go to the proper committee. Because this bill tells judges what they have to do as well. Because when a judge does a warrant, it's not a sign or release. The judge decides whether the warrant is valid and if there's bail or no bail. If there's no bail, why would you issue a warrant? You would issue a summons. So I think this bill needs to go back, be redone properly, go through the proper process so we can get it done right to make sure that we are making sure that the public is safe. And with that, members, I would ask for a no vote at this time so we can get this bill done properly. And I think it is something that we should look at, but like I say, we need to do it the right way and make sure that this bill is done properly. Thank you.
The representative from Chicago, Representative New Brindley.
Thank you, Mr. Speaker and members. So I actually think that probably most of my colleagues and I agree that we like the premise of this bill, the general idea behind the bill. And I suspect that had things gone a little bit differently today, there would be probably nearly unanimous support for the bill. But honestly, what we saw today during this debate just exemplifies the fact that this is not a serious bill and that my Democrat colleagues are not serious about getting this done properly. And it's really unfortunate. You know, we've already gone over several of these things, but, you know, I think Representative Stephen mentioned that the state has already said that these folks are not a risk and therefore they won't hold them on arrest. And I would ask again, then why are there exemptions in the bill at all? That's not serious. We had an opportunity to amend the bill so that serious firearm violations would at least be treated the same way as someone slapping another person in a bar. That would have been an indication that we were serious about getting something done. And instead, we have a situation, this bill was introduced into the legislature less than 3 weeks ago, well beyond deadlines. There is no Senate companion. The Democrats couldn't even get a Democrat in the Senate to offer this bill. There's no Senate companion. They also talked about all sorts of crazy outcomes from these things. Well, all sorts of crazy outcomes, that's what we get when we do legislation fast instead of doing legislation right. And what we are doing right now is trying to do this fast instead of doing it right. And it's really unfortunate because, like I said, I think if things had gone differently today, there'd probably be nearly unanimous support for this. We really do support the underlying premise. I think that there's a lot of good in the basic idea. But this is not serious. This bill is so botched. There's so many inconsistencies, even with what the Democrats are telling us about the bill. There are inconsistencies. That's not how we write laws. That's not how you legislate. It's a bad bill. It's a good idea. It's a terrible bill. Vote no.
To the author of the bill, Representative Long.
Thank you, Mr. Speaker. I think we should refocus on the situations that we're talking about here. We're talking about what should happen when an individual, with the amendment that we took today from Representative Novotny, makes very clear, has not received the notice of their court appearance. So they were mailed a summons, and that summons is bounced back, and there's a physical copy of that summons with a returned address. So there's physical evidence that that person never received notice of their trial. What should happen in those circumstances? Should the individual be arrested and taken into custody and detained because they missed a court appearance that they never knew about, which costs money for local jurisdictions to detain them, which takes time for law enforcement officers, and which increases risk, because any time that a law enforcement officer is taking somebody into custody, that's going to increase the risk. Should we have that approach, or should we have a common sense approach where we let the individual know that they have a trial date coming up? I think if you asked Minnesotans, they'd say, well, of course you should let them know about their trial date. That's the whole purpose, right, of the summons to begin with. So this is as common sense a bill as they come. And I'm glad to hear from members that they appreciate and support the underlying premise. I'm glad to hear from Representative Johnson that his sheriffs are intrigued and interested in this. I've spoken to members of law enforcement who are strongly supportive of this because they view it as good for them. They view it as a circumstance where they don't have to take somebody into custody unnecessarily, and where we have protections written into the bill where they get to make sure they're lowering the temperature even when they're interacting with citizens on these signatures. So, members, we can find a lot of excuses why not to move forward with bills like this. We've heard a lot about timeline. None of us in this chamber chose when Dante Wright was killed. That happened less than a month ago. We once again had the eyes of the world upon our state for the wrong reasons. We once again saw pain in our community members. We once again saw folks marching in the street and calling for change and asking us to try to help restore trust in our law enforcement and in our community safety. And so we as a body are not too slow and stuck to be able to respond to circumstances like this, particularly when there are common sense approaches that are workable, that are proven, where we know it could have saved somebody's life. We know that if this bill had been in place, Dante Wright would not have been arrested. He would have been given a sign and release warrant with the date of his hearing. I just also want to point out that we have put a lot of care into this bill. It has gone through our process. We had it introduced 3 weeks ago. Members, 3 weeks is a long time. We're working on a week and a half to put together our omnibus bills right now. We're going to get our targets probably, Friday, Saturday, and have like 5 days to work? Oh, today? Okay, great, today. So, have 4 or 5 days to work. We can work on short timelines. We have had 3 weeks to work over this bill. We've had a week since our hearing. We had a hearing on this bill. It's not like this has been rushed through. Anybody who wanted to engage in a conversation since that hearing could have reached out to me. We could have had a conversation. We could have worked on provisions in this bill to try to improve it if there were concerns that folks wanted to raise. This has not moved too fast, members. This has moved at the normal speed of the legislature, where we've had a hearing, where we're bringing it to the floor, where we're going through the normal process. I know that bipartisanship is hard. I know that it can be hard to come together on issues of policing. I know it can be hard to come together on issues of public safety. But this is an honest attempt at trying to do that. This is an honest attempt at trying to find a solution that can work to help protect the public and to protect law enforcement, that can help work for both sides. And I believe that this is something that the public is calling for. They want us to try to work together. They want us to try to find ways where our state can avoid having tragedies like this again. And we know that this is one way to do that. I urge member support.
Seeing no further discussion, the clerk will take the roll on the bill. Members, please vote. Will the clerk please call the names of those members who have not voted yet?
Anderson.
Anderson, no.
Anderson, no. Baker. Baker. Davids.
Davids votes no.
Davids, no. Davney.
Dabney, aye.
Dabney, aye. Drazkowski.
Drazkowski, no.
Drazkowski, no. Franzen. Franzen. Frazier.
Frazier, aye.
Frazier, aye. Garofalo.
Garofalo, no.
Garofalo, no. Gomez.
Gomez, aye.
Gomez, aye. Gruenhagen.
Gruenhagen, no.
Gruenhagen, no. Haley.
Haley, no.
Haley, no. Hamilton.
Hamilton, no.
Hamilton, no. Hanson, R.
Hanson R, aye.
Hanson, R, aye. Hausman.
Hausman, aye.
Hausman, aye. Heinrich.
Heinrich, no.
Heinrich, no. Hollins.
Hollins, aye.
Hollins, aye. Hewitt.
Hewitt, aye.
Hewitt, aye. Igo.
Igo, no.
Igo, no. Keel.
Keel, no.
Keel, no. Kosnick.
Cosmic, no.
Kosnick, no. Long. Long, aye. Lucero.
Lucero, red.
Lucero, no. McDonald.
McDonald, no.
McDonald, no. Mecklin.
Mecklin, no.
Mecklin, no. Mortensen.
Mortensen, aye.
Mortensen, aye. Pulowski.
Pulowski, aye.
Pulowski, aye. Schultz.
Schultz, aye.
Schultz, aye. Sundin.
Sundin, aye.
Sundin, aye. Thompson.
Thompson, aye.
Thompson, aye. Zhang Jie.
Zhang, aye.
Zhang Jie, aye.
The clerk will close the roll. There being 73 ayes and 59 nays, the bill is passed as amended and its title agreed to.